What is a patent? A patent is intellectual property. Now you might ask, well, what is intellectual property? It is a category of property that includes intangible creations of the human intellect. There are many types of intellectual property, and some countries recognize more than others. The most well-known types are copyrights, patents, trademarks, and trade secrets. Some records exist of a patent-type system being used in ancient Greece. The first known patent for an invention was granted in 1236 for woven fabrics with multicolor patterns. The first known English patent was either in 1449 for the making of stained glass or 1440 for the manufacturing of salt. Early patent systems reinforced the wealth of elites. Article 1, Section 8, Clause 8 of the U.S. Constitution states, "The Congress shall have power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries." The right to exclude others from making, using, or selling an invention for a fixed period of time in exchange for a complete disclosure to the public of how to make and use the invention is called a limited monopoly. In the U.S., the first Patent Act of the U.S. Congress was passed on April the 10th, 1790, titled An Act to Promote the Progress of Useful Arts. On July 31st, 1790, Samuel Hopkins was issued the first patent for a process of making potash, an ingredient used in fertilizer and also in making soap. Thomas Jefferson, who was the first patent examiner, kept files in shoeboxes. We used to search in large wooden file cases with actual patents, and the patent examiners called these wooden cases shoes. All searching today is done on computers. The earliest law required that a working model of each invention to be submitted with the application. In the U.S., patent models were required from 1790 to 1880. The United States Congress abolished the legal requirement for them in 1870, but the U.S. Patent Office, USPTO, kept their requirement until 1880. The inventors would often hire a professional model maker to turn a two-dimensional drawing into a three-dimensional miniature machine. The inventor also turned to other skilled craftsmen such as blacksmiths, watchmakers, or cabinet makers to fabricate models. However, even today, if the examiner is considering whether the invention is operative, they can require a working model. Abraham Lincoln is the only president ever to have a patent. Lincoln's patent was granted for a device for buoying vessels over shoals. The main types of patents are utility and design. In general terms, a utility patent protects the way an article is used and works. A design patent protects the way an article looks. The types of patents filed at the USPTO are utility, plant, design, and international. Some intellectual property organizations include WIPO, which is the World Intellectual Property Organization, USPTO, the Intellectual Property Office of England, and the European Patent Office. Most countries have their own patent office. Here is an example of a utility patent that I wrote. It is an apparatus for supporting a laptop or tablet computer when being used by someone in a reclining position with their knees bent up. Here is another example of a well-known utility patent to Play-Doh. It is a starch-based modeling compound. The parts of a patent utility application include specification, drawings, and claim. The specification consists of a written description of the invention in sufficient detail to allow one of ordinary skill in the art to make and use the invention. This example is an acoustic resonator coupling invented by my husband and prosecuted by Pearl Patents. Here is an example of the drawings for the same patent, and they are usually done by a professional drafting firm. The claims look like this. They are in single sentence form, and you will have an independent claim, as shown here, and then a series of dependent claims usually. As you can see, this claim is in single sentence form. It's very long. Claims that follow will say something like, the claim as in claim 1 and further including. Types of utility patents are mechanical, electrical, chemical, and plant. When my husband and I worked at the USPTO as examiners, we worked in the mechanical arts. The Plant Patent Act of 1930 is a United States federal law spurred by the work of Luther Burbank. This piece of legislation made it possible to patent new varieties of plants, excluding sexual and tuber-propagated plants. Its term is 20 years. In the United States, a design patent is a form of legal protection granted to the ornamental design of a functional item. Design patents are a type of industrial design right. Ornamental designs of jewelry, furniture, beverage containers, and computer icons are examples of objects that are covered by design patents whose term is 15 years. On the right, you can see a design patent for a very well-known beverage, Coca-Cola. Trademarks are a symbol, word, or words legally registered or established by use as representing a company or product. The term of a federal trademark is 10 years with 10-year renewal terms. However, the USPTO requires that between the 5th and 6th year after the date of registration, the registrant must file an affidavit stating that the mark is still in use. If no affidavit is filed, the registration is canceled. A copyright is the exclusive legal right given to an originator or an assignee to print, publish, perform, film, or record literary, artistic, or musical material, and to authorize others to do the same. Legal protection lasts the life of the author plus 70 years. How is a copyright different from a patent or a trademark? A copyright protects original works of authorship, while a patent protects inventions or discoveries. Ideas and discoveries are not protected by the copyright law, although the way in which they are expressed may be. Trade secrets are a type of intellectual property that comprise formulas, practices, processes, designs, instruments, patterns, or compilations of information that have inherent economic value because they are not generally known or readily ascertainable by others, and which the owner takes responsible measures to keep. The formula for Coca-Cola is a trade secret. They are valuable because they never expire. How to go about getting a patent. Number 1, keep a careful record of your invention. Record every step of the invention process in a notebook. Number 2, make sure your invention qualifies for patent protection. Number 3, assess the commercial potential of your invention. Number 4, do a thorough patent search. And number 5, prepare and file an application with the USPTO. Can an inventor file a patent application on their own? The answer is yes. A pro se patent applicant is an inventor who chooses to represent himself while prosecuting a patent application. Further, among applications that issued as patents, pro se's patent claims appear to be narrower and therefore of less value than claims in the represented patent set. Most inventors rely on the services of a patent agent or a patent attorney. A patent agent is a person who has passed the U.S. Patent and Trademark Office's patent bar exam. This means that the person is legally able to work on, file, and initiate applications for clients who are interested in acquiring a patent. A patent attorney is an attorney who has specialized in representing clients in obtaining patents and acting in all manners, including filing an opposition. There are benefits of using a registered patent agent or patent attorney. Number 1 is the expertise. To become a registered patent agent and represent an inventor before the U.S. Patent Office, one must have at least an undergraduate degree in engineering or science, in addition to passing the patent bar. Number 2, process knowledge. As many patent agents focus on only patent and trademarks, they understand the process that a patent must go through to get approval. Patent approval takes on average 2 years, and missing deadlines and/or overlooking key requirements will only extend the time or entirely cause the loss of patent rights, from conceiving an invention to getting a granted patent. Other benefits of having a patent agent include dealing with complexity. The patent process is unfortunately quite complex and is strewn with potential landmines that, if not avoided, can lead to the loss of legal rights. An experienced patent agent can help a person navigate the minefield. Number 4, legal advice. A patent agent will give an applicant advice on other aspects of the patent process, such as what type of patent to obtain, whether to file a provisional patent application, timing requirements, the relationship of filing your application to publicizing your invention, non-disclosure agreements, and other related subjects. Number 5, preparation and execution. Patent agents need to be organized and diligent in preparing and filing patent-related documents and tracking and meeting deadlines.